Reservation of name. Section 16. A person may apply in such a form of manner and accompanied by prescribed the duration for the reservation of a name set out in the application has the name of a proposed LLP or the name of which LLP proposes upon receipt of an application under subsection 1 and 1 subsection 1 and on payment of the prescribed fee, the registrar may, if he is satisfied, subject to the rules prescribed by the central government in the matter, that the name to be reserved is not one which may be rejected on any ground referred to in subsection 2 of section 15. Reserve the name for a period of 3 months from the date of intimation by the registrar. Change of name of LLP. Section 17. Notwithstanding anything contained in section 15 and section 16, if through inadvertence or otherwise a LLP on its first registration or on its registration by a new body corporate, its registered name is registered by a name which is identical with or too nearly resembles to that of any other LLP or a company, or a registered trademark of a proprietor under the Trademarks Act 1999 is likely to be mistaken for it, then on an application of such LLP or proprietor referred to in clauses A and clauses B respectively, or a company, the central government may direct the such LLP to change its name or new name within a period of 3 months from the date of issue of such direction. It is further provided that an application of the proprietor of the registered trademark shall be maintainable within a period of 3 years from the date of incorporation or registration or change of name of the LLP under this act. Where a LLP changes its name or obtains a new name under subsection 1 itself within a period of 15 days from the date of such change, give notice of the change to registrar along with the order of the central government, who shall carry out necessary changes in the certificate of incorporation, and within 30 days of such change in the certificate of incorporation, such LLP shall change its name in the LLP agreement. If the LLP is in default in complying with any direction given under subsection 1, the central government shall allot a new name to the LLP in such manner as may be prescribed, and the registrar shall enter the new name in the register of LLP in place of the old name and issue a express certificate of incorporation with new name which the LLP shall use thereafter. Nothing contained in this subsection shall prevent ILLP from subsequently changing its name in accordance with the provisions of section 16. Differences with other forms of organization. Distinction between LLP and partnership firm. The points of distinction between a limited liability partnership and partnership firm are tabulated as follows. Basis: Regulating Act LLP, the Limited Liability Partnership Act 2008, the Indian Partnership Act 1932, Body Corporate LLP, it is a body corporate. Partnership firm, it is a not body corporate. Separate legal entity, it is a legal entity separate from its member. It is a group of persons with no separate legal entity. Creation, it is created by a legal process called registration under the LLP Act 2008. It is created by an agreement between the partners. Registration is mandatory. LLP can sue and be sued in its own name. Registration is voluntary. Only the registered partnership firm can sue the third parties. Only the registered partnership firm can sue the third parties. Perpetual succession. The death, insanity, retirement or insolvency of the partners does not affect its existence of LLP. Partnership may join or leave, but its existence continues forever. The death, insanity, retirement or insolvency of the partners may affect its existence. It has no perpetual succession. Name of the LLP to contain the word LLP, Limited Liability Partnership, has suffix. No guidelines. The partners can have any name as per their choice. Liability of each partner is limited to the extent to agreed contribution except in case of willful fraud. Liability of each partner is unlimited. It can be extended up to the personal assets of the partnership. Mutual agency. Each partner can bind the LLP by his own acts, but not the other partners. Each partner can bind the firm as well as other partners by his own acts. Designated partners. At least two designated partners and at least one of them shall be resident in India. There is no provision for such partners under the Partnership Act 1932. Common seal. It may have its common seal has its official signatures. There is no such concept in partnership. Legal compliance. Legal compliances. Only designated partners are reasonable for all the compliances and penalties under this Act. All partners are reasonable for all the compliances and penalties under the Act. Annual filing of documents. LLP is required to file annual statements of accounts, statement of solvency, annual return with the registration of LLP every year. Partnership firm is not required to file any annual document with a register of firms. Foreign partnership. Foreign nationals can become a partner in a LLP. Foreign nationals cannot become a partner in a partnership firm. Minor has partner. Minor cannot be admitted to the benefit of LLP. Minor cannot be admitted the benefit. Minor can be admitted to the benefits of the partnership with the prior consent of the existing partners. Distinction between LLP and limited liability company. Regulating Act, the LLP Act 2008, the Companies Act 2013. Members, the persons who contribute to LLP are known as partners of the LLP. The persons who invest the money in the shares are known as member of the company. Internal governance structure. The internal governance structure of a LLP is governed by contract agreement between the partners. The internal governance structure of a company is regulated by statute, that is the Companies Act 2013. Name. The name of the LLP to contain the word limited liability or LLP has suffix. The name of the public company to contain the word limited and private company to contain the word private limited has suffix बाद में. Number of members partners. Maximum 2 partners. Minimum 2 partners. Maximum. No such limit on the partners in the Act. The partners of the LLP can be individuals or body corporate. तरफ the nominees. Private company. Minimum 2 members. Maximum 200 members. Public company. Minimum 7 members. Maximum no such limit on the members. Members can be organizations, trusts, another business firm or individuals. Limited liability of members and partners. Liability of partners is limited to the extent of agreed contribution except in case of willful fraud. Liability of a member is limited to the amount unpaid of the shares held by them. Management. The business of the company is managed by the partners, including the designated partners authorized in the agreement. The affairs of the company are managed by board of directors elected by the shareholders. Minimum number of directors, designated partners. Minimum number 2 designated partners. Private company 2 directors. Public company 3 directors minimum. Summary: a LLP is a separate special type of partnership that can be used as business organizations owned by certain types of professionals such as company secretary, chartered accountant, cost management accounting, lawyers, engineers, doctors and consultants etc. who are not allowed to use corporation form of entity to limit their liability. LLP is generally set up for carrying on a partnership con- consisting of partners carrying on practice in one or more individual professionals etc. Since India has witnessed considerable growth in services sector and the quality of our professionals have been acknowledged internationally, it was necessary that entrepreneurship knowledge and risk capital combine to provide a further memo- mem- momentum to our impressive economic growth. It is likely that in the years to come, Indian professionals would be providing accountancy, legal and various other professional technical services to a large number of entities across the globe. Such services would require multidisciplinary combinations that would offer a menu of solutions to international clients. In view of all this, the concept of LLP came into existence. LLP framework could be used for many enterprises such as persons providing services of any kind, enterprises in new knowledge and technology based field where the corporate firm is not suited for professionals such as chartered accountant, cost management accountant, company secretaries and advocates etc. Venture capital funds where risk capital combines with knowledge and expertise. Professionals and uh, enterprises engaged in any scientific, technical or artistic discipline for any activity relating to research, production, design and provisions of services. Small sector enterprises, producer companies in handloom, handicrafts sector. LLP has partners but no directors or shareholders. The major constituents of a LLP are its partners who are the ultimate owners. The LLP Act 2008 applicable 31 मार्च 2009 extend to whole of India contains 81 sections on 4 schedules. First schedule mutual rights and duties of partners. Second schedule conversion of a firm into LLP. Third schedule conversion of a private company into LLP. Fourth schedule conversion of unlisted public company into LLP. Non-applicability of the Indian Partnership Act 1932 to LLPs. Meaning and concept of LLP: new form of legal business entity with limited liability, alternative corporate business vehicle, allows the partners the flexibility of organizing their internal structure. LLP itself will be liable for the full extent of its assets. Liability of the partners will be limited. Important definitions: body corporate, section 2(1)(d) of the LLP Act 2008, a company and individual LLP, foreign company, non-include corporation, sole cooperative society, and any other notified central government by the central government. Business, section 2 subsection 1 clause E of the LLP Act 2008 includes every trade, profession, services and occupation, includes any activity notified by central government. Designated partner, section 2 subsection 1 clause J. Any partner, designated partner has such pursuant to section 7. Entity, section 2 subsection 1 clause K. Any body corporate and includes a partnership firm for specific purposes. Foreign LLP, section 2 subsection 1 M clause M. LLP formed, incorporated or registered outside India which stabilizes a place of business within India. Financial year, section 2 subsection 1 clause L. 1st April to 31st March. If LLP incorporated after 30th September, financial year may end on 31st day of March of next following that year. LLP agreement, section 2 subsection 1 clause O. Written agreement between partners of LLP or between the LLP and its partner. Written agreement between partners of LLP or between the LLP and its partners. Partners who may be section 5. Any individual or body corporate may be a partner in a LLP but not person of unsound mind, undischarged insolvent, or who has applied to be adjusted as an insolvent. Minimum partners, section 6. 2 partners. If LLP carries on business for more than 6 months with only one partner, shall be liable personally for the obligations of the LLP incurred during that period. Important concepts: small LLP, section 2 TA, contribution up to 25 lakh and turnover for immediately preceding financial year up to 40 lakh, or which fulfills prescribed terms and conditions. Designated partners, section 7. At least 2 designated partners who are individual and at least one of them shall be a resident in India. Resident in India, a person who has stayed in India for a period of not less than 60 days during in the immediately preceding 1 year. Incorporation of LLP, subscription of names by 2 or more persons, filing of documents with ROC with prescribed fees, compliance statement made by advocate CSCA, CMA and by any of subscribers. Documents containing name, proposed business, address of LLP, name and address of each of to be partners and designated partners, other prescribed information, issue of incorporation, issue of incorporation, certified certificate by ROC within 14 days. Important concept: name, use of words limited liability partnership or LLP has the last words of its name. No LLP registration by a name which in the option of the central government is undesirable or identical or to namely resembles to any other partnership firm or LLP or company or a registered trademark. Change of name: if name of registered LLP is identical or too nearly resembles to any other partnership firm or LLP or company or a registered trademark, central government may direct such LLP to change its name within 3 months on application. Characteristics: body corporate, perpetual succession, separate legal entity, mutual agency, LLP agreement, artificial legal person, common seal, limited liability, management of business, maximum and minimum and maximum number of partners, business for profit only, investigation, compromise or agreement, conversion into LLP, e-filing of documents, foreign LLPs. Descriptive questions: examine the concept of LLP. Meaning: a LLP is a new form of legal business entity with limited liability. It is an alternative corporate business vehicle that gives the benefits of limited liability but allows its partners the flexibility of organizing their internal structure as a traditional partnership. The LLP is a separate legal entity, and while the LLP itself will be liable for the full extent of its assets, the liability of the partners will be limited. Concept of limited liability partnership: the LLP can continue its self-existence irrespective of changes in partners. It is capable of entering into contracts and holding property in its own name. The LLP is a separate legal entity is liable to the full extent of its assets, but liability of the partners is limited to their agreed contribution in the LLP. Further, no partners is liable on account of the independent or unauthorized action of other partners. Thus, individual partners are shielded from joint liability created by other partners, wrongful business decisions or misconduct. Mutual rights and duties of the partners within LLP are governed by an agreement between the partners or between the partners and the LLP, as the case may be. The LLP, however, is not relieved of the LLP for its other obligations as a separate entity. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and the flexibility of a partnership. Since LLP contains elements of both a corporate structure as well as a partnership firm structure. LLP is called a hybrid between a company and a partnership. Enumerate, enumerate the various characteristics of the LLP. What do you mean by designated partner? Whether it is mandatory to appoint a designated partner. Enumerate the various characteristics of the LLP. The LLP registered with the registrar under the LLP Act 2008 has the following characteristics. Body corporate perpetual succession, a separate legal entity, mutual agency, LLP agreement, artificial legal person, common seal, limited liability, management of business, minimum and maximum number of partners, business for profit only, investigation, compromise and agreement, conversion into LLP, e-filing of document, foreign LLP, foreign. What do you mean by designated partner? Whether it is mandatory to appoint designated partner in a LLP. Designated partner section 2 clause J. Designated partner means any partner designated as such pursuant to section 7. According to section 7 of the LLP Act 2008, every LLP shall have at least two designated partners who are individuals, and at least one of them shall be a resident in India. If in LLP all the partners are bodies corporate, or in which one or more partners are individuals and body corporate, at least two individuals who are partners of such LLP or nominees of such bodies corporate shall act as designated partners resident in India. For the purpose of this section, the term resident in India means a person who has stayed in India for a period of not less than 120 days during the financial year. What are the effects of registration of LLP? Effects of registration. Section 14 of the LLP Act 2008. On registration, a LLP shall, by its name, be capable of suing and being sued, acquiring, owning, holding and developing or disposing of property, whether movable or immovable, tangible or intangible, having a COVID seal if the decides to have one, and doing and suffering such other acts and things as bodies corporate may lawfully do and suffer. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and the flexibility of a partnership excellence. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and the flexibility of a partnership. Limited liability. Every partner of every partner of limited liability partnership is for the purpose of the business of LLP, the agent of the LLP, but not of other partners. The liability of the partners will be limited to their agreed contribution in the LLP, while the LLP itself will be liable for the full extent of its assets. Flexibility of a partnership. The LLP allows its members the flexibility of organizing their internal structure as a partnership based on a mutual agreement. The LLP form enables entrepreneurs, professionals, and enterprises providing services of any kind or engaged in scientific and technical disciplines to form commercially efficient vehicles suited to their requirements owing to flexibility in its structure and operation. The LLP is a suitable vehicle for small enterprises and for investment by venture capital. Explain the essential element of incorporation on limited liability partnership under the LLP Act 2008. Essential elements to incorporate limited liability partnership under the LLP Act 2008. The following elements are very essential form of a LLP in India. To complete a submit incorporation document in the form prescribed with the registrar electronically. To have at least 2 partners for incorporation of LLP, individual or body corporate. To have registered office in India to which all communications will be made and received. To appoint minimum 2 individuals as designated partners who will be reasonable for number of duties including doing of all acts, matters and things as are required to be done by the LLP. At least one of them should be resident in India. A person or nominee of body corporate intending to be appointed as designated partner of LLP should hold a designated partner identification number DPIN allotted by Ministry of Corporate Affairs. A person or nominee by body corporate intending to be appointed as designated partner of LLP should hold a designated partner identification number DPIN allotted by Ministry of Corporate Affairs to execute of a partnership agreement between the partners inter se or between the LLP and its partners. In the absence of any agreement, the provisions as set out in first schedule of the LLP 2008 will be applied. LLP name.